it's Trace McMillan, and today we are doing a webinar on separation and what to do. All right, so you've left, okay? You've got all your documents, wonderful. Now what? What have you got to do? Let's start with you've got to do your will. If you're married and you haven't got a will, you need to get one. If you do have a will, you need to redo it. If you are married, again, you need to do an enduring power of attorney. If you already have one, you need to redo it if you've left it in favour of the other party. And I'll go through and explain what these are in a minute. You also then need to formally divide your assets and debts. That's what we call property settlement. And if you have children, you need to make arrangements for your children, whether it's informal or whether it's formal. It's a choice for you, but you do have to consider what's going to happen with the children about going backwards and forwards between the parents. Now, if you do have children as well, you're going to have to consider whether you're applying to the child support agency for an assessment for the other party to pay child support, or it might be you paying child support, but that is another thing you'll have to consider. And finally, if you are married, again, you will have to go through and do your divorce at some stage. All right, so a will. A will is the document that actually divides all of your estate, which is your assets, after you have died. Now, the reason this is important when you're separating is if you have a will in place right now, I'm gonna say 99% of you have left all of your estate in the first instance to the other party. So your spouse, the one you've just walked out on or they've left, they're the one you've left everything to, and in the event that they don't survive you, then it goes to your children. That's a normal way. Now, the thing about separation is it does not void your will. The only thing that will void your will in these circumstances is if you get remarried, which you can't do for quite some time. Now, if you're saying to yourself, that's all right, I don't have a will anyway, so that's fine. Well, guess what? If you die right now and you're separated, then your estranged spouse is still considered your spouse, and you die what we call intestate, which is without a will. So in the provisions and according with the law, and it changes state to state, but roughly it's the same for each one, it is your immediate partner or your spouse or estranged spouse is the one who will get the lion's share of your estate. So if you don't want them to have any part of your assets after you have died, then you need to do a will, and you need to do it quickly in case something happens. An enduring power of attorney. You may not have really heard about this before. Now, an enduring power of attorney is usually done around the same time as a will, and this is a document for when you are alive, but you have no legal capacity to make decisions for yourself. So for instance, if you've had a car accident and you're in a coma or you're unconscious, you no longer have capacity to make any decisions for yourself. So that is what an enduring power of attorney does. It allows somebody else to make those decisions for you. And those decisions can be both for personal health matters, so things like doctor-related medical issues, like, I don't know, switching off life support, and financial matters, such as transferring all the money out of your bank account, or transferring property between people and things like that. Now, again, if you're married and you do not have a power of attorney in place, then your next of kin is considered, yeah, you guessed it, it's your estranged spouse. So that might leave you a little bit nervous right now, especially if it means they're in control of your money and they're the ones who can decide whether to switch off your life support or not. I don't know about you, but I don't know that that would make me feel the most comfortable. If it does, great. If it doesn't, then you need to get that document in place, leaving it in charge of somebody else that you trust, and you have to trust this person implicitly, giving them that authority.